Number 126 and appeal number 127, BF versus Reproductive Medicine Associates and Dennehy versus Copperman, excuse me. Thank you. Good afternoon, counsel.
Good afternoon. My name is Nancy Letty-Gurn. I'm counsel for Dr. Alan Copperman. And in conjunction with the court's directive, my colleague Karen Lilling and I will split the argument 6 minutes each. We both request 1 minute in rebuttal, if that's okay with the court. And I'll direct myself towards the accrual issues, if it please the court.
Very good.
We submit on this appeal that the lower court and our adversaries have achieved a cosmic shift in the application of 214A, the medical malpractice statute.
But if the parents are, if the parents are seeking damages for the care of this child, don't you need the birth? Don't you need the live birth?
No, we maintain we do not need the live
How
birth.
could it be that there's no claim until there's actually a child alive that the parents are now responsible for?
Most respectfully, Your Honor, we believe that if we take a look, as we do in all accrual cases, as to the cause of action, the cause of action in a wrongful life case is a cause of action. It's a medical malpractice cause of action. And when you take a look at the accrual, you look at what is the essence of that cause of action. And the essence of the cause of action in this case is the claim that the failure to test the donor for a particular genetic disease interfered with the parents' genetic reproductive choices. The choice to select a donor, the choice whether to go forward with the pregnancy, the choice whether to become pregnant with this donor's.
Okay, but let's say there had been a miscarriage. That's not, it can't be tracked back to whatever genetic defect there is.
Correct.
Miscarriage for some other reason, okay?
Correct.
But they would not have a claim, right?
Yes, they most certainly would have a claim.
And isn't that because there's not a child born alive with the genetic defect?
What I'm suggesting to you, Your Honor, is if, in fact, there was a malpractice in a failure to diagnose the donor, and if it resulted in a donor that these plaintiffs did not want and in a pregnancy that they did not want, there is a remedy for that in a cause of action.
And you're saying they could recover damages even if the child had not been born alive?
Yes.
What are those damages?
Their damages would be for their personal damages in having to go through a IVF cycle and a pregnancy or a pregnancy termination that they didn't, that was performed incorrectly.
Have those
just like
damages
in sterilization cases.
Have those damages ever been recognized?
Take
by
a look
our
at O'Toole versus Greenberg, where they sustained the two causes of action by the plaintiffs in a sterilization case where there was a failure.
So
And they
in
said-
this case, because there's twins, right? There's
Excuse me?
there's two births that were involved here, right?
In one of the cases,
In one of the
there are two
cases, it's
births,
twins.
yes.
And if I understand correctly, one of the twins had the Fragile X syndrome, the other didn't.
Correct.
Under your theory, would, in the twin case, there be damages, would the accrual date be the same for both children?
Absolutely. The accrual
The
is
accrual
to the
date wouldn't
parent.
exist. You're saying it wouldn't make any, so it doesn't matter if they're born with Fragile X or not. You'd have a claim, a claim would begin to accrue on that date, even though you could, so let me finish the thought.
Sure.
Even though you couldn't possibly have damages for both of them, you could only have damages for one of them, because only one of them had Fragile X.
First of all, the people who have the damage are the parents. And
I
the
understand.
issue
No, I
is,
understand that,
what
but-
is the
but-
measure of those damages?
Right, and how do you measure damages in a situation like that where one of the children is born with Fragile X and one isn't, so the parents clearly can't be damaged on both, even though a claim, in other words, a conception would have occurred at the same time, let's say.
Correct.
And you're arguing that the date of conception is that date. And that's why, that's the flaw I see in the argument that disturbs me, only because we're not talking about negligence here, we're talking about the tort in its entirety, and the tort in its entirety demands measurable damages.
The injury that occurs is the interference with their reproductive choice. The measure of their damages, whether they are going to incur costs for a child that's impaired, or they're going to incur costs for their own physical damages, is going to have to be sorted out. I agree with you, Your Honor.
The only reason I raised the point is because the 80s analysis relied on damages as an element of the tort in their underlying logic. And since one child would create damages for the parents and the other child clearly wouldn't, the date of conception for accrual doesn't seem logical to me.
Well, it doesn't, but except that I ask you this. There is nothing about the date of birth that informs
Sure it
that
is.
there
That's the
is-
date when you
that
know.
there is-
Let me just finish. That's the date you know unfortunately, one of the children has Fragile X and one doesn't. That's the date you know that.
No, sir.
Well, you're saying
respectfully,
earlier
you
on in
don't.
testing.
You don't. The fact of the matter is, in this
Okay.
very case,
Yeah, it took, I don't know, 4 months. I'm not sure of the time frame. It took a few months.
this took, the children were over a year old.
2 years.
And in other cases, other genetic cases, since we're making a rule that's not going to apply just to Fragile X,
could they not have known if the child was tested at birth?
could they have known
I
if
mean,
the
isn't the
child...
delay you're talking about because of the time when the company knows and notifies them? As opposed to when they could have actually found out, which is at birth?
Could they have tested, if their obstetrician had chosen to do a test,
Well, they could have requested it. Right,
or
they
they
could
had
request it.
requested it,
Correct.
they might have found out, yes,
Yeah.
Okay.
correct. But the point is that the notion that the date of birth, per se, will establish in any one of these cases a damage is a fantasy. The fact of the matter is, not only for this case, but for the cases across the line that you want, that the plaintiffs, that the court wanted us to apply it to. The fact of the matter is, there's no evidence that genetic defects appear on the date of birth, and they're picking a date of birth as the date of accrual.
Assuming that's true, I just want to clarify one thing. So the damage, you don't agree that the damages are the costs of raising a disabled child? You think the damages are what happened before the birth?
I'm saying,
Or both?
that's the measure of damages.
Well,
I'm saying the injury is to the parent.
Well, okay, if we accept that, which,
Okay.
I mean, certainly.
injury is to the
We have cases
parent.
that say for wrongful birth, the injury is to the parent. The injury is the cost of the additional costs and expenses of raising a disabled child. So but you were referring to other kinds of costs, the cost of the pregnancy, the cost of the in vitro fertilization. So are you saying that they're both part of the damages, or are you saying only the pre-birth costs are the measure of damages?
Okay, I'm trying to distinguish to the court the difference between injury and the measure of damages.
I understand that. So you're talking about measure of damages. Does the measure of damages include both pre-birth and post-birth, or
Yeah.
just pre-birth?
The measure of damages will include all.
Thank you.
But the injury occurs and is complete at the time the malpractice occurs.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. May it please the Court. My name is Karen Lilling on behalf of Defendant Appellant RMA. I'm listening very intently to the Court's questions, and I want to try to answer them in perhaps a little differently. CPLR 214A doesn't consider, doesn't regard, doesn't care when the injury occurs or when the measure of damages can be effectuated.
So CPLR 214A was enacted in 1975, and then Becker
Yes.
was decided a
And
couple
then
of
Becker
years
was-
later.
Yes, and it was, in fact...
So my question
Yes,
to
Your
you is, do you think that the legislature envisioned this cause of action at the time that they set where I think you're going with this?
I'll say yes, Your Honor, because in the Becker decision, this cause of action was addressed, but it wasn't called wrongful birth. In fact, it was called wrongful diagnosis, which actually highlights and underscores, I think, Ms. Guerin's point for the moment, that the injury that we're talking about is a deprivation of choice for an improper diagnosis. But let me, for this purpose, beyond my statement that CPLR 214A is statutory, it does not consider date of injury, it does not consider measure of damages. Now, yes, the First Department deviated from that and looked to birth, stating that we can't know what the injuries are. They call them the injuries, the measure of damages, whatever you'd like to call it, until the child is born. However, I will assume for the sake of argument that the injury is the increased financial obligation. Let's even assume that for this purpose. What the First Department overlooked was your decision in Goldsmith versus Helmetica. This case is critical to this analysis. Goldsmith versus Helmetica makes it crystal clear that the statute of limitations in a medical malpractice actions runs from the time of the act, even in the absence of any injury, until and unless the legislature declares otherwise.
And in Goldsmith, didn't we in fact cite 214A, although it wasn't applicable in Goldsmith, to say it doesn't change the calculation? So if that's the case, if Goldsmith applies, then distinguish Labello.
Yes, Your Honor. Labello is very distinguishable from the case at bar, and in fact, the appellate division even recognized that it was not controlling in its decision, because the plaintiff was not in existence in Labello. And what the court in Labello said is that 214A never contemplated that the plaintiff would not be in existence. In this case, the plaintiffs are the parents.
And I believe
they-
Labello also cites the infant toll, right? In
Yes,
support
Your
of the
Honor.
position.
And the
You're-
plaintiff,
You were relying on Becker, is that correct?
it's relying on Becker to the extent that Becker, it was the case where this court determined that there was no cause of action for
For
wrongful life.
conception. Wrongful conception, right?
Or, yes, Your Honor,
Yeah.
or wrongful life.
I had thought the timing of that rule arose prior to any in vitro fertilization at all. In other words, is that correct?
Yes, Your Honor, well, if
Does that
that is
affect your
correct.
analysis at all?
No, it doesn't, Your Honor, and despite what might be perceived as the inherent unfairness, case after case in this court, when a statute, the medical malpractice statute, has been looked at, it has been adhered to strictly, no matter the outcome.
So can I just clarify the sort of the analysis you're proposing here? Is it your position that even if the parent gave birth to a child that doesn't have the mutation, they could sue?
No, Your Honor.
Why not?
Well, they could sue who does not have the mutation.
Right.
Then it would go back to Ms. Guerin's argument, which perhaps there were injuries that they sustained separate and apart from the increased financial obligations
I
of
thought you said
having
it's not
that
related to
child.
the injury.
I'm
I
sorry.
thought you
Your
said there was a claim even if you have no injury.
We're talking about different types of injuries?
No, no,
and
but I
different
thought,
types of
I may have misunderstood you.
Oh, I'm sorry,
I
Your
thought you were arguing that you have a claim even without the injury. The clock starts running even if you suffer no injury. At the moment in time the malpractice occurs.
Well, if I may, Your Honor, and
Yes,
I see that
please.
my time, but I think this is an important distinction. I say yes to that in light of the Howmedica case. You see, and I think it's worth exploring, in Howmedica, the malpractice occurred in 1973, but the injury didn't arise until 8 years later. There was no injury. There was no measure of damages. The plaintiff could not have known. And then the plaintiff brought a medical malpractice action in 1983, 10 years after. And this court, even though Goldsmith versus Howmedica, the statute of limitations was 3 years because it predated the enactment of 214A, this court considered and cited and reflected on 214A when it refused to extend the statute of limitations in the Howmedica case past 3 years. And I think the language of this court's decision is very compelling and controlling in this case. Plaintiffs also claim that to require the bringing of an action within 3 years of the commission of the malpractice effectively forecloses an action against the doctor before any injury has been suffered. Much like this case, it was an implantation of a device that didn't malfunction until many years later. The argument is not new. We have carefully considered it on numerous occasions. In each, we weighed the detriments of such a result against the effect of potentially open-ended claims upon the repose of defendants and society, and held that the statute of limitations must run from the time of the act until the legislature decrees otherwise. And that, Your Honor, is a case that I feel is controlling in this case, and the reason why the appellate division's decision should be reversed.
Thank you, counsel. Counsel?
Thank you, Your Honors. My name's Wendy Fleischman, and I'm here on behalf of the Farber plaintiffs. And I wanted to address the accrual issue first. I don't think that this court should reverse the First Department's decision on accrual. Doesn't make sense.
Would you address Goldsmith?
Yeah.
Yes,
Yeah, I think,
that's the easiest place to start.
good.
Goldsmith is like a failure to diagnose cancer case. When the conduct occurs, the injury, for the doctor, the injury actually occurs. So in Goldsmith, the doctor had actually placed the device improperly into the hip, and that's why 7 years later, that hip component failed. And so, but it wasn't until the failure that the injured person came forward and said, oh my gosh, this really hurts, and then all the rest occurs. But the incident of the malpractice did occur when the doctor didn't place it properly, in the same way as this court has historically
So
determined.
when did the incident of malpractice occur here?
The incident of malpractice doesn't occur here because it's absurd. At the time that the two children are in utero, there's no way to know one way or the other.
To knowledge, it's the same thing as the hip. I mean, you're arguing kind of two different things here. The malpractice has occurred in your case, you just don't know it. It's the same way because it's a failure to screen. So it's the same way that a hip implant, a malpractice has occurred, but you just don't know it. So what they considered to me in Goldsmith was, you don't know it, you can't bring a claim, you don't even have any damages yet, but that's not for us, that's for the legislature. And I don't understand how your claimed malpractice is different than the Goldsmith malpractice.
The Goldsmith malpractice is different because if you think of it in a failure to diagnose cancer case, which is in.
But I don't want to think of it
Okay.
that way, I want to think of it in
But
your case.
in my case, in the Farber's case, there's the failure to diagnose the donor as having Fragile X, as being carrier Fragile X, is not the injury. The injury in a wrongful birth case is the parents having to pay the money to take care of an injured child.
Like the hip fails, so that's the injury.
The hip.
Well,
the hip-
is your point that there's no malpractice until the child is born with the genetic
Yes.
defect? Because if, of course, the child doesn't have the genetic defect, where did the doctor go wrong? Is that
Well,
what
if
you're
the-
trying to argue?
If the child's not born with a genetic defect, as baby B was, there was no malpractice.
The child has a genetic defect before it's born.
But the genetic defect doesn't show itself in baby B, because baby B in this case has a pre-mutation. He doesn't have a full mutation for Fragile X.
Problem
That's
doesn't
why
show
he's not a
itself in a hip
plaintiff.
replacement either. We're talking about the injury, and I think it seems counsel's argument is a pretty strong one, that Goldsmith sets this rule. Labello is different, and Labello has a certain kind of appeal here because we're talking about a birth, but it seems to me Labello is talking about something very different, which is you don't have a plaintiff yet because you're bringing the claim on behalf of a child who doesn't have capacity yet, isn't even born, and you get into tolling issues. That's Labello. Why isn't this Goldsmith?
This isn't Goldsmith because there's no actionable injury at the time that the children are in utero. There are, for many reasons, those children...
Just change in utero to Goldsmith,
But
the
the
hip
children-
doesn't fail yet. It's just that it's in utero. It isn't the same problem as Labello.
There's no certainty that the children in utero will survive.
Same question I asked to counsel before. Doesn't the fact that the twins, one had the defect, one didn't, show that you don't know and you have nothing to work with until there's a birth?
Yes, Your Honor.
So that would support your theory that the possibility of a tort existing only takes place upon birth.
Yes,
But
Your Honor.
how is that? I don't understand
There's
why
no
that's true.
actionable tort. You have, the same way as in Labello, there was no actionable tort until the baby
There
was
was no
born.
plaintiff in Labello. It wasn't that you didn't have all the elements of the claim. What Labello cites for that is a contract case, which I think is Kronos, but they really don't rely on the elements of your claim having come together yet in terms of the act, the injury. What Labello relies upon is it's unfair and not contemplated by 214A to make someone bring an action when they don't exist. So the child has no legal capacity to bring an action, and it implicates these tolling provisions for an infant until they're born. But Labello doesn't really rely in any way on the cause of action hasn't come together at the time until the time of birth. And so you're asking us, I think, to apply Labello in a different way that to me will impact the Goldsmith rule.
If Your Honor goes back and looks at Labello, Labello actually does speak to exactly the fact that this is a tort and that you can't have a tort and you can't have a cause of action in a tort unless you have an injury.
They talk about that, and again, they cite a contract case for that proposition. But
Well, actually,
really
they cite a lot of
They
tort
cite
cases as well.
Kronos for the most part. But the basic point of Labello is what they didn't contemplate in 214A was not having a plaintiff who could bring an action. Not that the cause of action hadn't solidified or come together yet, but that you don't have an actual person who can come into court and bring this claim. And when you read that in conjunction with a tolling provision for infants and the protection we give to them as plaintiffs, this is something different. And you're asking us, I believe, and maybe we will do this, to expand the Labello because it's in some way a birth case into this case, which to me then starts to come into conflict with the Goldsmith rule.
Well, isn't the birth important? Because the mom says, had I known and had this information, I would not have carried this pregnancy to term?
Yes, Your Honor. She actually would not have even accepted the donor egg and her husband's sperm,
That's not the
embryo.
damages here. That's a wrongful life claim. Your damages are the excess costs, right?
Well,
Well,
isn't,
if
isn't,
it
isn't,
causes-
excuse me, isn't the analysis in Labello, and I think it isn't directly on point, I think Judge Garcia is correct about that, but it offers some language that's compelling to the court and may affect our analysis. It says that the statute of limitations cannot run until there is a legal right to relief. It doesn't say the statute of limitations runs from conception, even though this is a wrongful birth case. It doesn't say that the statute of limitations begins to run when there's an injury to be alleged, but instead when there's a legal right to relief. And so the question for us then, and I can't say I know the answer to this, but the question for us is, that may be an extension of our analysis. My colleagues argue that, and that may be true. The question is whether we should extend it in this instance to that analysis and that language to this case.
Well, that language follows with two additional pieces, that accrual occurs when the claim becomes enforceable. This claim was not enforceable when Mom was pregnant with those two babies.
Was the HIP claim enforceable when it hadn't failed yet?
Right.
No.
A tort is enforceable when all its elements can be truthfully alleged in a complaint. We could not have truthfully alleged in the complaint in this case that the failure to diagnose the donor with Fragile X would have resulted in the parents having to incur all these additional expenses.
So you're saying if you had actually filed,
We would have
when
dismissed.
I was going to ask, you would have been open to a challenge that is premature and you don't have a claim and you'd be dismissed.
Right, right. So you can't, so it would be absurd to put us into that situation.
Thank
So-
you, counsel.
Thank you, Your Honor.
Counsel?
Good afternoon, Your Honors. James Lacowski, I represent the Dennehys, the companion action to this. Judge Garcia, I was listening to what you're saying. A claim didn't exist here until this child was delivered live, because what we're seeking to
I agree with you on
Yeah.
that. But why isn't that Goldsmith? A claim didn't exist until the hip failed.
because there's
Why
no-
is this different?
Because what's seeking to be recovered here cannot be recovered unless there's a child that's born.
But
You-
you
you
can't
can't do it.
recover in a hip failure case until the device fails.
You know,
What's the difference?
Your Honor, this is one of those unenvisaged circumstances that Labella spoke about.
No, Labello spoke about an unenvisaged circumstance being you don't have a plaintiff, and you don't have anybody who can come into court and actually assert this claim, not that the claim hadn't come together in terms of you have all the elements. And I think what Goldsmith speaks to in the language that your adversary quoted is, that's unfair sometimes,
And
but
then-
it's a fix for the legislature.
And, Your Honor, it could be unfair with starting the accrual at the date of birth in this case and other cases as well, because it's a 2.5-year bright line. There's no discovery rule that, if we were arguing a discovery rule, it would have been starting in
Understood.
May of 2010, right, when the parents found out or were notified.
No, I understand.
But similar to Labello, and I think this case is more, I disagree with
Well,
you, Your
look,
Honor. I think
isn't-
this case is
isn't-
more similar to Labello than
Isn't
you
the
think.
difference between the hip case, which I think is what counsel was trying to get to, that in the hip case, the injury is at the time, right, of that malpractice.
Correct, Your Honor.
You're going to suffer particular consequences somewhere down the line, and that might put you all of a sudden to realize, oops, a long time ago this doctor messed up,
Yeah.
and now I'm suffering. But
correct,
until
Your
a
Honor.
child is actually born, you don't know at all whether or not you're going to suffer any consequences.
So would the
And-
Goldsmith rule be different then if you implanted a device correctly and the device is fine, but it fails at some point? And so until the point it fails, for whatever reason, which wouldn't be discoverable, and maybe it isn't even a problem till it does, then would you get from the date of failure or would you get from the date of implant under Goldsmith?
Well,
Isn't the
that
point
may be a
whether or
product-
not...
That may be a
isn't the
different product
point-
liability case with respect to the
Counsel,
date of failure.
Counsel, isn't the point whether or not the implantation of the device itself was the malpractice? Because if it's not and it fails for something else, maybe you have a product's liability
That's
case, but
exactly
you don't
what I'm
have
saying,
medical
Your Honor.
malpractice.
It's not a med mal case with a 2.5-year statute of limitations. What's, back to your point, Judge Garcia, about a claim that, an infant doesn't exist, so cannot bring a claim. Until an infant exists, the parents here can't bring a claim. So it's analogous in that sense that the parent can't just bring the claim unless this child exists and has.
So to
this,
that point, let's
deficit.
say there's a diagnosis before birth, and the parents incur costs related to, we're going to have this child and they're going to be special needs, but the baby is not a live birth for other reasons. Would they be able to recover those costs or no?
I don't know about in a medical malpractice case. I mean, I don't know if there's a contract issue there or whatnot, but I don't know if they'd be able to recover those costs, Your Honor. Especially not in a wrongful birth case where you're seeking recovery for the extraordinary costs associated with raising a child with deficits until their majority. Again, some statute of limitations can have harsh results. If a phone call was never made and these people never found out about it, 2.5 years would have passed from the date of birth, and we'd be up here arguing that maybe you should have a discovery rule.
Let's say we disagree. Let's say we view the case differently. I'm just curious, is there an argument that the statute should be told, given the misrepresentation by the
Well,
company?
now you get into like an equitable estoppel
Yes,
situation.
I am asking that
Yeah.
question, correct.
if there was some type of fraud and some type of concealment,
Well, those claims got dismissed, you didn't appeal them, so.
They did. They did. And there is it's interesting that you bring that up.
But you didn't make a
Judge Rivera.
tolling argument.
No, we did not make a tolling argument. It's a purely bright line, starts from the tide of birth, 2.5 years. The equitable estoppel and the fraudulent concealment's interesting because there was a number of months that went by from the doctor finding out to him reaching out to these families to let them know that there's that issue.
Thank you, Counsel.
Thank you very much.
I would just like to make...
Counsel, what about the tolling argument?
The
They
tolling
didn't make it, but could there have been a tolling argument?
I'd like to, no, for the following reasons. One thing that has remained unsaid in any of the briefs, certainly by the plaintiffs, is these plaintiffs, as judged by the law as 214, from the time of the malpractice, discovered their injury and had a year and a half left to go before the statute expired. These are not plaintiffs who discovered their injury when the time had already
But
lapsed.
whatever the rule is that we say it is going to apply to other people,
Yeah,
to whom
so-
that won't
no,
be
no, but I'm
applicable.
just saying, these are not plaintiffs who woke up one day
I
with their
understand.
cases time barred.
So
They
you
had a
think-
year
you-
and a half to bring it, and so
that the
there's no
certified- Excuse me
room
a
for an
second.
equitable estoppel argument on that fact alone.
You say that we can't reach the dismissal of the other claims here because the certified question hasn't brought that up, right?
Yeah, yes.
Do you agree that after a final judgment, if the court takes it, we can then reach that question?
Yes.
Thank you, Counsel. Counsel?
Thank you, Your Honors. The principles of law in the Halmedica case, that case was a malpractice case. It was also a products case, but first and foremost, it was a medical malpractice case brought against a physician who implanted a device 8 years prior. The basis for the malpractice, the act, was 8 years before any
But
damages
counsel argues that they
materialized.
would have been open to, they would have been subject to dismissal, because it would have been a premature claim.
But that is true in many cases, Your Honor. It's true.
No. Would you not have filed a motion to dismiss as premature?
Of course, Your Honor. However, and there are many other instances where the damages or the injury is not manifest on the date of the malpractice. It's true in cancer cases, and I didn't have the opportunity on my direct to talk about Laverne's Law and the impact of Laverne's Law that is currently passed and before the governor to sign. That is limited to extending the statute of limitations in cancer cases when the injury cannot be known at the time of the malpractice to 2.5 years from the date of either knowing or should have known, but not more than 7 from the act. There were earlier versions of the bill.
But there's one slight difference here.
Yes, Your Honor.
As I see it, okay? And that is that theoretically, at least, if the, if the defective hip was implanted on a certain date, the injury potentially could have been made known sooner, whereas in this situation, there is no possibility of knowing whether there will ever be a cause of action until the child is born.
How I would answer that, Your Honor, is this. In the Halmedica case, the implant malfunctioned. So whether or not it could have been, it might, yes, Your Honor, you're correct. It perhaps could have been
It could
detected.
have malfunctioned after a week or a month or a year.
But
I
the
mean, that's potential. Here, there is no possibility that, as I understand it, and scientifically or whatever, that this could have been known until after the birth of the child.
What I would say to that, Your Honor, and again, perhaps not a perfect answer, is that there is prenatal genetic testing that can be done on a mother to determine whether or not she's a carrier for certain genetic deformities.
Well, whether the mother is a carrier.
I'm sorry, the fetus, I apologize, I misspoke, Your Honor. The thing that I'd like to end with, and also was not yet discussed, but certainly is in the briefs, and I recognize my time, Your Honor.
You may.
Thank you, Your Honor. Is Jorge, is the line of cases that precedes this case. And while this court did not make a formal determination that the statute of limitations in a wrongful birth claims runs from the date of the malpractice, had
It wasn't even raised in that case, was it?
that, well, no, Your Honor, but I still would
Well,
like to.
It's not a matter of it being raised and it was never decided. It was never.
It was not
even
decided, Your Honor. But however, the appellate division, interestingly, in the first department, decided clearly that the date of the malpractice was governing in a wrongful birth claim. And in fact, had it, and the continuous treatment doctrine ultimately did not apply, but had it been the date of birth, the action would have been timely. And so the first department, in its decision, marks the date of the act, the date of the malpractice, as marking the beginning of the statute of limitations, and ultimately, this court made a determination that continuous treatment did not apply. But had it been the date of birth, then that Jorge would have been timely. And after Jorge came Scruffini in the second department. After Scruffini came Weed in the fourth department. This is not a point of law that has been in dispute, meaning it has been since Becker, through O'Toole, through Jorge, through Scruffini, through Weed, and it wasn't until Ciceron, the second department, citing Labello, by the way, incorrectly, suddenly and without explanation, changed the statute of limitations from the date of the malpractice to the date of the birth. And what I would say to Your Honors is that is erroneous, and if the statute of limitations is to be extended, it is only a function of the legislature. And I thank you.
Thank you, Counsel.